presentation. The way we're going to work this is I'm going to say a few additional remarks by way of introduction, and then Harold Koh will speak for 40 minutes, and then there'll be about 40 minutes left for, or I guess 20 minutes, I can't do math, left for Q&A, and then we'll end right at 1:30, and the students who have been bused can run down and get on your bus so you don't miss those. Can I just, this is probably the biggest audience that I ever remember at one of these events, and I just want to get a sense of who's here. Let's start out with, raise your hand if you're a member of the Cleveland International Lawyers Group, so all the attorneys that are here. All right, great turnout. Now, who's here from Cleveland State Law School? I know there's a delegation, a couple of you guys are, okay. Who's a law student at Case Western? All right, quite a few. And then visitors, other people in other categories, quite a few. So lots of perspectives to join this amazing organization. I want to say a little bit about the Cox Center and the Klatsky, because you're looking at what's on the slide behind us, and you're saying, well, who's Klatsky and who's Cox? So Frederick Cox in 1991 was the executive director of the Gun Foundation. And that was when we got a $4 million endowment from the Gun Foundation that launched the Case Western International Law Program. It's one of the biggest endowments of any international law program in the country, and it literally overnight put us on the map. But this year, U.S. News and World Report, which just released its rankings, has us at number 15 in the country, and we're very proud of that. We do a lot with that money. A lot of the students that are here are going to be going overseas in the summer, working for international tribunals and NGOs and the United Nations and international organizations, and that's all being funded from that money. Now, Klatsky is Bruce Klatsky, and he was a member of our Board of Trustees, and in 2001, so 10 years after we had endowed our International Law Center, he came and gave us another $300,000 to launch a human rights program. And with that money, we are able to bring in major lectures every year and send 2 students to Human Rights Watch. And we have these 2 dedicated slots there, and he actually calls up and makes sure the students get a top choice, and he's very involved in the program. Bruce Klatsky, unfortunately, could not be here today. He's in Australia. He has an amazing international business practice, and so he's in Australia, and he wanted me to tell everybody that he sends his regrets, but he's here in spirit. And he's very proud that the money that he gave us has really launched a thriving international human rights area at our law school. So I want to tell you just briefly about what we do in that area. First, Avi Cover from our clinic, can you raise your hand or stand up? He is launching a new human rights law clinic, which will be initiated next year. And next to him is Tim Webster, one of our professors. He teaches human rights law. And we have a number of courses and labs where our students get hands-on experience working on human rights issues. We send our students to human rights organizations all over the world, and we're very proud that a number of our graduates are now at these organizations, and they're changing the world. So this is an area of law where people say, why are you going to law school? And the students will say, because I want to change the world. And 10 years later, they'll say, how is that going for you? And the students can actually list the ways they changed the world. Now, speaking about people who've changed the world, Harold Koh has done so in many ways, and for his efforts, we are very proud to present to him our Humanitarian Award for Advancing Global Justice, which we have presented in the past, and many of you have been at those, to some of the luminaries and leading figures in human rights and international justice. So if you remember back, we had Navi Pillay, who was the High Commissioner for Human Rights. We had Philippe Kirsch, the president of the International Criminal Court, Christopher Greenwood, the judge from the UK at the International Court of Justice. We had Fatou Bensouda, the prosecutor of the International Criminal Court, and many others over the years. And I think of all of them, you guys are in best luck because Harold Koh is not only a wonderful humanitarian, but one of the best lecturers I've ever seen, and I've seen him many times lecture. But if you ask yourself, why is Harold Koh being honored in this way here? And he's had many, many other honors as well. He's done a lifetime of service to human rights. When he was just a professor at Yale, he initiated the Human Rights Clinic. And the Human Rights Clinic at Yale really jump-started the whole area of Alien Tort Claims Act litigation. And with Keogh Bell, we'll have to see whether that will be continuing, but it is an area that has brought human rights to light through U.S. courts. He was then asked to be the Assistant Secretary of State for Human Rights at the U.S. Department of State. And he was there during many of the major crises that have shaped human rights around the world. The Haitian crisis, the Kosovo crisis, and his fingerprints are in all the solutions to those. He went back to Yale, became the dean of the law school, really continued to make that law school a huge mover in the field of human rights. And then he was called upon to be the legal advisor at the U.S. Department of State. This is the lawyers that do international law for the U.S. government. And I started out my career there. In fact, Harold was very, very generous to me. I have a book about the role international law plays in times of crisis, and he wrote the foreword to that book. And I think many of you have read that foreword. Raise your hand if you've read that. All right, look, you have fans out there, Harold. It's not like they were assigned that or anything, right? So anyway, at the State Department, he continued to excel and change the world in many positive ways. And so we are really fortunate here to have visiting us in Cleveland, here at the City Club, which has been the venue for so many famous speakers over the years, and speaking to this crowd of lawyers and law students and others, a real visionary, a real person who has made such an impact in this important field. And without further ado, I'd like to present this award to Harold and have him come up and speak. And you can just slide that there.
Well, what can I say? Cleveland rocks, right? Michael bought me at the coffee house that we went to just now a T-shirt that says, "Cleveland is my Paris." And it's great to be back here with so many friends. I have former students, colleagues from the State Department, members of the two law schools. I made some new friends last night singing at the St. Patty's Day Jam with Dean Scharf at the Jolly Scholar at Case Western Reserve. And some of the people who heard me nevertheless came back today, which I find quite remarkable. As Michael said, my last 4 decades, I spent more than 30 years as an international law professor, 5 years as a dean, 20 years as a human rights lawyer, and 10 years in the U.S. government. Just to give you some pictures, the upper left-hand corner is appearing before the UN Human Rights Council in Geneva, upper right at the Kremlin for the Nuclear Security Summit, bottom left, Afghanistan, bottom right, Guantanamo. I first went to Guantanamo in 1992, and I've been there now, I think, 19 times. On the left, Iraq. In the middle, Greece for the financial crisis. Far right with Secretary Albright at the funeral of Kim Dae-jung, former president of Korea, Nobel Prize winner. And I appeared in many courts, the International Court of Justice on the left in the Kosovo case, the European Court of Human Rights in Strasbourg, the African Court of Human and People's Rights, and as the head of our delegation to the International Criminal Court. And I took many flights. This is the most famous. This has become a meme. We were flying into Tripoli after the Libya intervention, and we were on a transport plane from Malta. And because Secretary Clinton was there, they put on these 4 nice seats, and we got on, and they started taking pictures of us. So I texted to her, "Look over your shoulder," and that's what she's reading. And I worked on many issues, both, as people would say, natural disasters and man-made. WikiLeaks, Haiti, the earthquake, Japan, the Fukushima meltdown, Arab awakening, human rights issues, international criminal law, Dean Scharf's specialty, cyberspace, economic and private international law issues, public health. Here I am with Chen Guangchen, the blind Chinese dissident, with whom I spent a number of days in Beijing, and here he is in his apartment at NYU. The most challenging issues concern the fallout of September 11th, which is now nearly 13 years ago. So in my capacity as legal advisor of the State Department, I played a number of roles. I mentioned them in the introduction to Michael's book. I was the managing partner of a law firm of about 200 lawyers, about 350 people. I was the general counsel to Secretary Clinton. It's like being the general counsel of any government agency, except we buy buildings, but they're in Kabul. We get visas, but in Baghdad. I was the internal conflict manager in the department for a far-flung department, as Ambassador Hodges knows. A unique role of the legal advisor is to be the designated spokesperson or conscience of the U.S. government on international law. If the U.S. is doing something that speaks to the issue of international law, it is, I think, the duty of the legal advisor to explain why we think the position is legal. And then finally, if we get sued in any forum, whether in international court or in a domestic court, I am the designated defender, or I was the designated defender. So I was of counsel on numerous Supreme Court briefs, and I also appeared and argued in a whole bunch of different international tribunals. It was a great job. So what are some things that I find, as I've now left, people don't fully grasp? By the way, here's a picture of my brother. My brother, Howard, is the Assistant Secretary of Health and Human Services. He is the highest-ranking public health official in America. My mother loves the picture because it looks like President Obama works for us. She's a... you know, the first is that you're not the only lawyer. As I said, in the State Department, there are 200-plus lawyers. At the Defense Department, how many lawyers do you think there are? Anybody want to guess? How about 17,000? 17,000. Justice Department, probably 10 to 15,000 lawyers. Treasury, National Security Council, CIA, Director of National Intelligence, Homeland Security. So in a U.S. government position has to be brokered between all of these agencies, not to mention the White House Counsel's Office, National Security Council, Lawyer's Office. One interesting thing is academics often say, you know, the legal opinion of the government stopped where it got interesting. And the short answer is that's where they stopped agreeing. Right? You know, what they didn't say is because they couldn't get an agreement on a position. So they just stated what they could agree upon and kept moving forward. Secondly, and it may be obvious, is you're not your own client. You know, when you're a professor, you can just say whatever you think is right. But if Hillary Clinton is your client, she's pretty smart. And if she works for Barack Obama, he's pretty smart. And they're both lawyers themselves. So the question is not whether what you think is the right thing to do lawfully. The question is whether what your client wants to do is legally available to them or not. So you can say to them it's legally available. You can say to them it's legally unavailable. For example, I think torture is legally unavailable as an option. Or what is often the case, or not often the case, but sometimes cases, you say it's lawful, but it's awful as a matter of policy. And here's an incredible thing. I wrote a lot of books and articles. The precedent that you follow is not what you said in your private capacity. They don't care what Harold Koh wrote when he was coming up for tenure in a footnote at age 29. What they care about is the opinions of the Office of the Legal Advisor, which have gone back since 1848. And when the people in my office look to the precedents of the office, they look to the precedents of the Office of the Legal Advisor, which is as it should be, because after all, where has more thought gone in? In an opinion that's been brokered with thousands of other lawyers in the government on matters of life and death after a career in international law, or something you threw into a footnote in an article to complete a tenure piece. Now you have many roles, as I said, and perhaps most important, you must play the hand you're dealt. You don't get to choose. There's a famous story about the two guys from Galway. They're walking down the road. I say this because St. Patrick's Day was yesterday, and my wife is Irish. And one guy says to the other, "How do you get to Dublin?" And the first guy goes, "I wouldn't start from here." So if you had said to me, "Would you like to be legal advisor in a time of peace and prosperity? Or instead, would you rather be the legal advisor during 3 wars, Afghanistan, Iraq, against Al-Qaeda, the Taliban, associated forces, in the worst economic crisis since the Depression, and then you throw into it natural disasters in places like Haiti and Fukushima, and then throw into the mix the release of millions of documents in WikiLeaks, et cetera, and then add to it the most toxic political environment in American history, which has created a set of deadlock. And you might say, I wouldn't start from here. But you don't get to choose. You play the hand you're dealt. And I can analogize this to people who do criminal law. You could, over the course of a long career, be an expert on criminal law. Sometimes you do criminal defense work, sometimes you do prosecutions, sometimes you're a judge, sometimes you're a professor. You're always doing the same body of law, but you're going to emphasize different things depending on what role you're in. So you're not going to emphasize the same things if you're a white-collar defense lawyer and if you're a prosecutor. That doesn't mean that you're inconsistent. It just means that you're playing a different role with the same body of law. So I found this to be an interesting challenge. I consider myself through my lifetime to have the exact same commitments with different roles. I'm a man of peace, I think. I have spent my life teaching international law. I believe I'm a defender of human rights, and I happen to be for 4 years a lawyer for a nation at war. And I tried to do that to the best of my ability. It wasn't easy. It was, in some ways, a relief to return to the academic world where I can just say what I want and nobody cares. But I say that because I'm sometimes asked, if you're a human rights lawyer, how did you defend drones? And the answer is pretty easy. I think all torture is illegal, no matter how it's used. I don't think the president can be the torturer in chief. But it is the very nature of the laws of war, which is called international humanitarian law, that some killing is lawful if it's done in the context of the laws of war. You may not like it, but if you are the lawyer for the U.S. government, it is your inescapable duty to draw a difficult line between lawful and unlawful killing and those which do or do not save innocent lives. And you have to defend those lines. And it's much better that you have people who care about the rule of law and human rights doing it than people who don't care. So there is a baseball manager who once said when he was getting flack for a decision he made, "That's okay over there. Their job is to say stuff. Over here, my job is to do stuff." And I would encourage everybody here to take their time in the government, because there's a long, long way from a good idea to actually getting it done. Now, obviously, 9/11 changed our lives. It was itself a grotesque human rights violation. 3,000 innocent people got killed for going to work. It signaled a new kind of war between a terrorist network that crosses borders and whose goal has been essentially to attack civilian targets in major Western capitals. It demanded a strong response, but one that was also respectful of human rights. It's combined in a blog that I now write for in the idea of just security, not just security, but a just security, in which law is an important piece, not lawfare, as it's sometimes dismissed by some, but in fact a way of thinking about how to defend our human rights while not making the 9/11 era the new normal. And I think that has been one of the great challenges. Now, against this background, you face constant challenges. And I'll give you this example. My very first day of work, I came in and somebody said to me, Harold, it was like 8:30 in the morning. We just got a call from customs at one of the major ports. The cryogenically frozen embryo of a panda bear is being held in a metal tank and it's being attached by private litigants, and the question is this embryo entitled to foreign sovereign immunity? And it occurred to me, you know, I think the framers of the Foreign Sovereign Immunities Act may never have thought of this question. Or I'll give you this one. We have a group of soldiers who are called Cyber Command. One of the great ironies is the various combatant commands have these guys who are tremendously physically fit. The guys in Cyber Command look like Jack Black, kind of. Their fingers fly across the keyboard. If you have a guy sitting in Fort Meade, Maryland, who hits a keystroke and it creates an effect in another country in the world and brings down a server, is that subject to the Geneva Conventions or not? And guess what? The Geneva Conventions and the framers of the Geneva Convention did not think about that issue. More than that, the problem of having 21st century problems in 20th century international law cuts across the board. Why? Because the great spasm of international lawmaking came after World War II, the UN Charter, the IMF, the World Bank, the WTO, or the ITO, which became the WTO. Most of the national security legislation we have was adopted in the wake of Vietnam and Watergate in the early 80s, 70s. International Emergency Economic Powers Act, the Arms Export Control Act, Intelligence Oversight Act. I've written about all of these. In recent years, we don't have new laws. Congress, as you know, doesn't approve treaties. Congress doesn't pass many statutes. The branches of government have great difficulty enacting even a way to avoid our default on our debt or raising of the debt limit. So the law will not change through normal amendment processes. So what is it then that allows us to adapt 20th century international law to 21st century problems? Do we have a strategy? Not just a way to solve a particular problem and get through the day, but do we have a strategy? And I want to argue that we do. And it's called international law as smart power. I'm going to make a strong claim for this. Not only is it a strategy, it doesn't always work immediately, but the alternative, which is a hard power approach, tends not to work either. And worse than that, it tends to lead to kind of structural failure. My colleague at Yale, Paul Kennedy, writes about the decline and fall of the great powers. He talks about how century after century, the leading hegemon tried to use hard power, and then they get into a situation what he calls imperial overstretch. They simply don't have enough soldiers, and then they collapse and they're replaced by another world hegemon, which is briefly ascendant and then falls prey to the exact same phenomenon. A sustainable strategy cannot be one in which we use troops and hardware and the threat of force to achieve every outcome. And it's also not one that plays to the advantage of having a system that we call international law developed from the 2nd century. Now, think this. There are two broad alternatives if you have 20th century law and 21st century problems. One I will call the black hole approach, or you can think of it as the Tina Turner approach. What's law got to do with it? What's law but a sweet old-fashioned notion? And I would argue that that was the fundamental approach taken by the last administration in response to 9/11. You know, we've been hit. It's a new situation. There are no legal constraints. We're in a black hole. We should respond and do whatever is necessary. And forget about the framework of international law that's been established. Let's disengage from the UN. Let's disengage from the International Criminal Court. Let's disengage from the Human Rights Council. All of these things. The black hole approach. The Geneva Conventions under this scenario are quaint, said the General Counsel of the White House, Alberto Gonzales. In other words, since they didn't anticipate the situation, they're irrelevant. So what's the other alternative to black hole? I'd call it translation, the spirit of the laws, Montesquieu called it. In other words, the law that we have has some object and purpose. What is the response to a particular situation which is most true to the spirit of the law that we have, even though it isn't written to address the current situation? It's an interpretive challenge in which you try to construe existing law to meet an existing circumstance. So I want to argue, and if you remember nothing else, remember these three words, that the strategy, international law of smart power, means engage, translate, and leverage. When in doubt, the United States should engage with other partners around our values, not disengage. Second, when in doubt, translate. Don't argue that there are black holes. Apply the spirit of the laws to meet the 21st century challenges. And then if you have a point of leverage, use law with other tools to produce policy. And military force is certainly part of this package, but you don't try to do everything with hard power. You also use diplomacy, development, technology, markets, international institutions, etc. Engage, translate, and leverage. And I would contrast this to an opposite view. Unilateralism, not engagement. Black hole, not translation. Going it alone, not leveraging your resources. Now, where did this come from? You could call this an Obama-Clinton doctrine. President Obama, in his inaugural address, I put this picture up mainly to show how young he used to look. These jobs take it out of you, boy. He says, a new era of engagement has begun where respecting laws and living our values doesn't make us weaker, it makes us safer and stronger. In other words, engage around our values. And then Hillary Clinton argued that we should use a smart power approach, the full range of tools at our disposal, including respect for law, human rights, public-private partnerships, etc. Now, people thought it was just a slogan, but my job was to give content to this. And if you Google Hillary Clinton and smart power, you'll see dozens of speeches that she gave over 4 years sketching out this strategy, which I think can be remembered as an Obama-Clinton doctrine. Now, how do you apply this strategy to 4 kinds of 21st century challenges? Human rights, international criminal justice, assisted reproductive technologies, and 21st century war. I could give dozens of examples. But let me start. Take Burma. Aung San Suu Kyi was under house arrest. She was a duly elected leader. With regard to Burma, we had imposed stiff sanctions, increasingly stiff sanctions. And then the question, do we engage with her? Do we engage with the Burmese regime? We did both. Then do we translate a strategy for imposing sanctions, a ratchet up strategy with a ratchet down strategy, action for action, and then try to leverage that into rule of law and human rights? And now, Aung San Suu Kyi is the chair of the Parliamentary Committee on Rule of Law and Human Rights in the Burmese legislature. Or how about this one? LGBT issues. Now, the last administration did little on this issue. In fact, they disengaged from the Human Rights Council. Hillary Clinton was going to the Human Rights Council because we re-engaged and got elected twice. And the question, what speech does she give on Human Rights Day? And she went and gave a speech in which she said, quite simply, LGBT rights are human rights and human rights are LGBT rights. This is a pure translation exercise. Do you see? She said, whatever you thought human rights were, they include the rights of LGBTs. So all the apparatus of protection that we have developed over the years to protect human rights now protects these individuals. And she had said this before at the Beijing Women's Conference, where she went as First Lady and said, women's rights are human rights. In other words, we're not going to treat human rights as rights that attach to a very limited group of individuals. And then leverage this foreign policy initiative with a set of domestic initiatives, elimination of don't ask, don't tell in the military, provision of same-sex benefits in both government and private jobs, challenging the Defense of Marriage Act, supporting litigation on same-sex marriage at the U.S. Supreme Court in the Windsor and Perry case. And you have in 6 years a sea change in the treatment of LGBT issues in the United States of America and worldwide. So now it's Uganda that's on the defensive for having anti-gay legislation. Or how about Chen Guangchen? This guy was a dissident. He was under house arrest in Shandong. He escaped. He broke his foot. He contacted the U.S. Embassy and asked whether he could come in. We could have said, no, we're not going to jeopardize our relationship with China for one guy. Instead, we decided to engage, bring him in, and engage with the Chinese government about his future. And one of the issues that was raised was, can he really be allowed to come into the embassy? I had to give a legal opinion on this while traveling in China. And people said, we can't possibly have a legal opinion which allows every single person in China who fears persecution coming into our embassy. And I said, maybe not, but we could have a legal opinion which says that the United States has a right to admit somebody for emergency medical care for a short period of time, and that's a sufficient basis for him to come in. And then working with a private institution, New York University, we leveraged this first into his leaving the embassy and then moving to the campus in New York, and he's now in the United States continuing his human rights work. Engage, translate, and leverage. How about international criminal justice? In your CLE materials, and I'm eager to see whether I can get some CLE credit for my own speech. I have an article that I'd ask you to read at some point called International Criminal Justice 5.0. Obviously, the U.S. pioneered international criminal law at Nuremberg and Tokyo, and then supported a series of ad hoc criminal tribunals, Yugoslavia, Rwanda, Sierra Leone, Cambodia, but then put itself in the bizarre posture under the Bush administration of attacking the standing international criminal tribunal, the International Criminal Court. So we're supporting ad hoc tribunals and we're opposed to the standing tribunal, even though the ad hoc tribunals are phasing into standing international criminal justice institutions. So the question is how to align those policies so they make sense, even though Congress has passed laws preventing us from financial support for the International Criminal Court. So part of the strategy, which we put forward quite simply, was we don't change any laws because we can't. We don't have the votes. But we will turn the policy around. I said to my son, it's like the time when we turned around the car in our garage without opening the doors. It's going to take a long time, and we better hope nobody notices. But as you notice, we engaged for the first time. We went to all the different conferences. We've shifted our position to one which now says we do not oppose the object and purpose of the ICC statute. We support all pending prosecutions, including the Libya referral. And the policy has turned 180 degrees. Or how about this one? Shortly after I became legal advisor, someone comes to me and says, there's a lesbian couple that's living in a foreign country. I won't say which one. And they have had a embryo and a fertilized embryo implanted into one of the members of the couple, who is an American citizen. Neither the egg nor the sperm is from an American, but this woman will carry the baby to term over 9 months in this foreign country and deliver that baby. What is the citizenship of the baby? Now we look at the law, and it says that the law requires that the child have a natural relationship with a U.S. citizen parent. That had been construed to mean a genetic relationship. What's the problem? Obviously, the woman is carrying to term a fertilized egg with whom she has no genetic relationship. But the term is not genetic, it's natural. So we had a meeting, and my conclusion was natural means genetic or gestational. That's translation. You know, I didn't find it anywhere, but it seemed reasonable with the spirit of the laws. The alternative is to leave the kid stateless. You know, his mother is an American citizen. It struck me as consistent. And this is now the prevailing interpretation. I say this because the great challenge, and one of the things I'm working on for the future, is the human rights of clones. Maybe one of you here is a clone. I'm not going to ask, but as they say, we have the technology. But have we done the thinking on this necessary? Imagine this. Could every one of you come here with your clone partner? Would you respect that person's human rights, or would your clone partner be your slave? Or how about this? If you suddenly had a heart problem, could you take the heart of your clone and have it implanted into you and use that person's body for your spare parts? Do you treat them like illegitimates or people of a different sexual orientation as they used to be treated, as lesser beings? Now, they weren't born human beings in the sense of being born live, but they are the product of modern technology. Assisted reproductive technology is a now common way to make families. And we don't have a human rights theory for clones, but we better get one. And that's something I'm going to be hoping to spend a fair amount of my time thinking of in the years ahead. Or how about cyberspace? So by its very nature, cyberspace is something that nobody drafting rules of international law in the 20th century thought of. And think about it, there are actually 4 different dimensions. There's freedom on the internet, which of course we would like to promote, but on the other hand, internet freedom can also pay for terrorist financing or communications to allow people to attack civilian targets. And interestingly, the Universal Declaration of Human Rights, Article 19, presciently thinks about the right to seek, receive, and impart information and ideas through any media and regardless of frontiers. It's almost like it's thinking about the internet in 1948. But there are at least 4 other dimensions of the internet: intellectual property and piracy, e-commerce, cyber security, and cyber warfare. So the question is, can we develop a regime that balances the competing concerns? Now, there are some countries, particularly China, have offered a theory of black hole, which is there is no law. What's law got to do with it? And I wrote an article in the Harvard International Law Journal which argued, no, it's a translation exercise. International law governs cyberspace. We engage through diplomatic law talk at fora like the Group of Governmental Experts, the World Conference on International Telecommunications. We make it clear that cyberspace is not a law-free zone, and we try to leverage it into various standard-setting exercises through projects like the Tallinn Manual, etc. Or take this. Most war these days is not conducted by soldiers. It's conducted by private security contractors, you know, Arnold Schwarzenegger. You see movies about this all the time. The Expendables 2, the Expendables 3. Did these guys have to follow the Geneva Conventions? They're not soldiers. What's the solution? Engage. We developed a set of principles called the Montreux Document. We translated it into an international code of conduct that now governs 500 companies. We leveraged it through private contractors to internalize norms into contractor behavior. This is, of course, the subject of my academic writings, norm internalization. And then what about Arab awakening? And this is one of these things that happened on our watch, all of the countries at the bottom of the slide. And Secretary Clinton said something very profound to me early on. She said, it's crazy, but you know what? Most of these people don't want to join Al-Qaeda. We need a smart power strategy to address that. And what does that mean? It means that we try to win the hearts and minds of ordinary Muslims in their home countries to try to get involved in economic and political development at home. But there will be a group of hardcore al-Qaeda who are not likely to become Democrats. You know, I'm sorry, Osama bin Laden was not about to convert and become the head of an opposition party. And so, on September 11, 2011, Secretary Clinton gave a speech called the Smart Power Approach to Counterterrorism, where she said, use force for limited purposes in a broader framework that deploys diplomacy, development, education, people-to-people outreach, challenge the ideology, the propaganda, the appeal. But in the short term, precise and persistent force remains a necessary part of the package. Now, why do I say that? Because after I got in and the use of drones began, a lot of people suddenly started saying, this is just like the last administration. There's no difference. To which I say, imagine this thought experiment. 7 days after September 11th, Congress passes an authorization of use of military force against al-Qaeda, the Taliban, and associated forces. Suppose the winner of the popular vote is the President of the United States. And suppose he appears and says the following things. I'm speaking now to the whole world. We've just been attacked. 3,000 civilians have been killed of many different nationalities. That's a grotesque human rights violation. I want to tell you what I'm not going to do, and I'm going to tell you what I am going to do. I am not going to invade Iraq. I am not going to torture anyone. I am not going to open Guantanamo. I am not going to set up military commissions. I am not going to kidnap people and put them in black sites. All of these things are illegal, they're wrong, and they destroy our legitimacy. But here is what I must do. I'm going to apply a smart power approach to counterterrorism in which our main goal is to speak to the people of moderate Islam. But with regard to those people who did September 11th, if they're in a cave in Tora Bora, I will use every technological means available to me as Commander-in-Chief, including drones, to suppress the threat. If I can arrest them, I will. But if I need to use weapons of war, I will use them consistently with laws of war. I'll be transparent. I'll consult with our allies. I'll consult with Congress. And God help us that this is over soon. Do you see the point? It's not about drones. If he had said that, we would say that's an essential piece of the picture. The fact of the matter is that drones are not a strategy. They're just a tool of war. They're not inherently illegal or legal. There are some tools of war that are inherently illegal, like chemical weapons, landmines. Drones are not one of them. Whether they're illegal or not depends on whether they're used consistently with the laws of war. So the strategy is engage, translate, and leverage. Engage with our allies, translate legal rules into lawful strategies of targeting and detention, and leverage this with a broader approach to counterterrorism. Now, it took a while, but finally President Obama brought this policy explicitly there last May at the National Defense University. He said, we have to define the struggle. There is no global perpetual war on terror. We need to end a forever war. We should repeal, replace, and not expand the authorization for use of military force. Drones can be part of a smart power approach if properly used. Along with other tools, they can be an effective and discriminate tool to help dismantle specific terrorist networks that endanger the United States. What he didn't say is this. It's one thing to say we're leaving Iraq if it's still violent there. It's another thing to say we're leaving Afghanistan if it's still violent there. But if we have not actually defeated al-Qaeda, they could attack us again on our own soil. And then people would say, what were we doing for 13 years? Now, it's been a long struggle, but it seems to me that the three aspects of this, and I've written a speech on this called How to End the Forever War, is number one, disciplining drones. We need more transparency, we need more consultation, and we need more standard setting. Secondly, defining the enemy to end the war. We are not at war with everybody who doesn't like us. That's a lot of people in the world. We're at war with those people who would attack us on civilian soil and have proven capacity to do that, and that's essentially the Al-Qaeda, the Taliban, and associated forces. As we disengage from Afghanistan, the issue of the Taliban will be a separate issue. But self-radicalizers like the guys at the Boston Marathon are not part of Al-Qaeda. We didn't declare war on them. And third, to use a comprehensive approach to ending all three wars: declining military engagement, continued civilian engagement, developing civil society, enhanced diplomacy to bring about diplomatic solutions in these conflicts. And on Guantanamo, which has been a source of continuing disappointment, the president remains and says, again, he's determined to close it by the end of his presidency. And interestingly, if he does, and the war is declared over, he will lose his legal authority to detain. And so in the last 6 months, more movement has happened there than happened in the previous 4 or 5 years, with a whole set of policy processes. And I'm happy to answer in Q&A exactly how this can be done. Block transfers to Yemen, a new envoy who's doing an outstanding job, moving to trials, preferably in civilian courts, releasing the releasable in periodic review boards, et cetera. Now, what about 2 other cases, humanitarian intervention? Case number 1 was Libya. Again, people think of Libya as a military operation. It was a smart power operation: engage, translate, and leverage. Join with many allies, translate that Gaddafi has forfeited his responsibility to protect, which creates a gap which must be filled by outsiders. The United States helps to establish a no-fly zone and then maintain it with an arms embargo, but along with assets freeze, diplomacy, travel ban, accountability before the ICC to protect civilians and rebuild the country. Now, Libya is not a perfect environment by any stretch of the imagination, but the fact of the matter is that this worked. I'm often criticized about this by my colleagues at Yale, and I say 10,000 to 15,000 people are alive today because of this approach, so I'm not apologizing. What about Syria? The problem here was they started again with a smart power approach, how to combine diplomatic strategy and engagement with smart power to achieve a number of objectives: secure chemical weapons, get a ceasefire, oust Assad, secure humanitarian aid, and secure accountability. But the problems, of course, were a persistent Russian veto. No Security Council resolution was therefore possible. There was a limited threat of a capacity to threaten force. If you think that the Security Council has a monopoly on the use of force in these situations. So that created a mismatch between the soft power tools that were available and the broader objectives. President Obama, unfortunately, has been better on politics, on principles, than on the politics to achieve them. How to re-energize the diplomacy. Suddenly, after the acknowledged use of chemical weapons last August, the president threatened hard power, and in such a surprising way that there was universal opposition. That changed the issue into our conduct and called into question his commitment to engagement, soft power, and ending the war. And suddenly it looked like he was going back to the old way. So what happened? Putin, Mr. Democracy, Mr. Human Rights, Mr. International Law, writes an op-ed in the New York Times in which he says, we must stop using the language of force and return to the path of civilized diplomatic and political settlement. That's pretty hilarious. In other words, he plays the soft power card. So what happened? The fact of the matter was the threat of force jump-started diplomacy. The administration's position, led by Secretary Kerry, mutated back to engage, translate, and leverage. And they shifted finally to where they should have been, a smart power approach. And though it's happening slowly, the Organization for Against the Proliferation of Chemical Weapons is moving weapons out. It won the Nobel Peace Prize. What about the Ukraine? And here's where I'll end. We have this situation, obviously, Crimea. The Russians are trying to annex it. This, by the way, should call into doubt in all of your minds whether Vladimir Putin cares the least bit about sovereignty in Syria. He clearly cares not at all about sovereignty. And he's using a transparent dodge to annex Crimea. And the U.S. has asserted that the people of the Ukraine must determine their own future in direct dialogue. The referendum that just occurred, we have correctly called, under both domestic and international law, illegitimate, contrary to the Ukrainian constitution, illegal under international law. The key weapon is targeted smart sanctions on the plutocrats who could influence Putin to change his outcome and attempt to insert UN monitors into Crimea, and various techniques of multilateral outcasting. Now, I was the person who argued for the independence of Kosovo at the International Court of Justice. This is a dramatically different situation. You should be very skeptical about referendums that occur under the barrel of a gun. And you should be very skeptical about the claim that Crimea can declare its own independence when it's actually the people of the Ukraine who have to declare the independence of Crimea. So this will be a battleground in the months ahead. We'll watch it play out. It will be a battle between the hard power approach of Putin, who is now moving more troops in, and a smart power approach on the other side. Who will prevail? Here's a situation where hard power is not a live option. So the question is, do we have the courage of our convictions? How consistently and multilaterally can we apply this approach to bring the issue to ultimate resolution? Yesterday, yet again, in the New York Times front page, David Sanger has another story about Obama's policies of retrenchment, what's viewed as weakness. Well, I'm sorry, we don't have a better alternative than the one he's put into play. You know, some people like surgery and other people use chemotherapy. And guess what? Sometimes chemotherapy works, but you've got to go with it. But I hope I persuaded you that not every episode may be a success, but there is a strategy here. And this is not Hugo Grotius's international law. This is 21st century international lawyering. Treating international law as a critical element of smart power is a better way to do it and to address 21st century problems. Engaging, translating, and leveraging law as a tool of smart power. It's an extraordinarily interesting time to be an international lawyer. I'm excited for you students who are getting into this field for the first time and watching all of these things play out. I encourage you to think about this in broad strategic terms and not just what gets us through the next week. So I'm delighted, and thank you very much for this great honor. I'm delighted to receive it and happy to answer any questions you might have.
Or Ray will take one.
Oh, by the way, I should have said that the CLE materials have some stuff on this which you might find interesting. There are two articles I wrote, one called 21st Century International Lawmaking, the other called International Criminal Justice 5.0, which lays out some of the dimensions of this. Obviously, it's a big part of a bigger project, which I'm sort of putting together in my own mind. So take a look at those materials. I think you'll find them interesting.
Okay, so raise your hand if you have a question, and then I'll bring you the mic on this side, and Ray will bring you the mic on that side.
Professor Koh, I'll start with the Henry King question here. Just because we're on the subject of the Ukraine right now, isn't this a bit of a flip for you on the theme? Isn't this a classic 20th century problem that you've now got to start with, try to solve, or has to be attempted to be solved with 21st century methods or approach?
No, well, no, because I think that all of the different apparatuses of this are. So, for example, under Ukrainian law, the Ukraine must vote. One question is, what is the role of the diaspora in this? Can they return and participate in the vote? Second question is, what does it mean for Putin to say that the people who are there are protecting Russians? I didn't notice that they were under threat. But I think the most elaborate response is the smart sanctions approach. During the Cold War, Russia was isolated. Soviet Union was isolated. That made fewer levers to put pressure on. Now there are deep interconnections. As we all know, the breakup of the Soviet Union led to the grotesque enrichment of very small numbers of people. Those people do things like buy basketball teams, spend huge amounts of money. Guess what? They like to travel. They like to put their money abroad. Those people have more influence over Putin than people realize. Just remember all the people who said that the only way to respond in Iran was to nuke their centrifuges. And guess what? We're working our way now to a multilateral deal because sanctions actually worked. Just think of all the people who said that we would never get anywhere with Burma with the use of sanctions and the enormous changes that came about there. So I think, this is the difference between chemotherapy and surgery. But we're very sophisticated now in how these things are used. The whole of the US government is involved. Treasury sanctions now involve incredibly elaborate processes. And the most important thing is isolating and outcasting and tightening all the screws. I mean, nobody thought that the Russians would give way for a Syria chemical weapons deal. By the way, one of the reasons I object to those who believe that the UN Security Council has a monopoly on the use of force in these situations is, the UN Charter's purposes are much broader than protecting territorial sovereignty. What does it mean to protect territorial sovereignty in the age of the internet? The purpose of the UN is to protect human rights and many other things. And guess what? In the Cuban Missile Crisis, we did not say that the fact that the Russians were going to veto a resolution meant that we couldn't do anything. We figured out legal responses involving a quarantine that allowed a mechanism to operate outside the UN that didn't give it a stranglehold of the Russians. I'm surprised now because many international lawyers claim, if the Russians are going to veto, we have absolutely no choice that to let the slaughter continue. If that's really so, then any P5 member, permanent 5 member, can commit genocide in its own territory, and nobody can do anything about it. That cannot be consistent with the object and purpose of the UN Charter. The human rights revolution extends to this. Now, I want to make a tough point here. There are some people who are pacifists. Many of them came out of the Vietnam War. That's when I grew up. They do not believe that the use of force is ever appropriate. I respect that. I just don't think that that's how. I grew up in a different era. I saw diplomacy backed by force create a situation in Dayton that led to a resolution of the Balkans crisis. I saw the lack of use of force in Rwanda lead to the slaughter of thousands. I really don't think that the goal of the law was to permit one nation to block action and let thousands of innocent civilians get slaughtered. If that's what the law condones, then we don't have a very good interpretation of the law. And those people who say doing something would be legitimate but illegal, that to me is ridiculous. Did we say same-sex marriage is legitimate but illegal? Or did we try to figure out a way in which you understand and reconcile your understanding of the law with what you think are the basic dimensions of justice in that circumstance? Kosovo was in 1999. This is 2014. The law has not evolved since then. international lawyers thinking haven't been able to figure out a way in which you can both preserve the integrity of the UN system and prevent innocent lives from being taken. I said to Michael before, there's a great irony. You know, if you read Barack Obama's Nobel Peace Prize lecture, he said something quite similar to what I said. He said, I've just been elected president. I'm getting a peace prize at the same time as I'm commander-in-chief of the strongest military force ever assembled, and my job is to extricate ourselves from 3 wars, and I'm going to have to use force to do it. And he goes, I believe in humanitarian intervention. I believe that force can be used consistently with rules, and it is my deepest dilemma as to how to resolve my basic commitments to peace, justice, and human rights with the duties I have to my citizens in my country. So it's not an easy time. And if you believe that force is part of the package, the question is how do you use force effectively, not irresponsibly? You know, blunt force trauma like invasions of Iraq turn out not to be very helpful. And they completely tap us out. So we have, you know, much more limited and targeted use of force. One of them happens to be drones, but let's face it, those people who are worked up about drones, 10 years from now, if someone fires a drone, it's not going to be taken out with a drone. It's going to be taken out with a cyber command. So let's not fixate on the technology. Let's fixate on the application of the law to the technology. The history of law of warfare is increasingly precise use of targeted weapons, starting with bows and arrows, to catapults, to bombs, to guided missiles, and now to even more automated devices. The question is how to bring those, and then it will soon be cyber commands. And the question is how to bring those technological developments under a framework of law and not under a framework of black hole.
We have time for one more quick question. Maybe one of the students. Okay, well, go ahead.
Thank you very much for speaking. Going a little bit to the idea of adapting, but also with technology. I definitely get a sense throughout, and you mentioned it explicitly, that much of the lawmaking, you know, apparatus at the federal level is stuck. But I see going forward this problem not unlike what we had in World War I, where the laws of war were set in the Napoleonic era, and now you get into a period of trenches, of airplanes, of chemical attacks, and it was so egregious, it went so far beyond any realm of adaptation that you literally had to rewrite the rules. But under the current, at least within the US, under the current paradigm, that trying to get some sort of comprehensive future arrangement is next to impossible. Is there a point you see where the abilities of translation will just fail? And if so, and if the paradigm doesn't change, what is a possible way out? Because there's only so much that even a very expansive State Department or administrative law regime, there's only so far it can go without some sort of lawmaking, some sort of legislative lawmaking power to change the system. So is there a point where it has to change, and if so, what is that change?
It's an excellent question. The materials that you have, the CLE materials, include an article I published in the Georgetown Law Journal called 21st Century International Lawmaking. It described the myriad ways in which we now develop law not through formal treaty processes or statutory processes. My view is actually translation goes pretty far. I found very few examples where it really did fail. I mean, drawing distinctions between civilians and combatants, defining the scope of an armed conflict, defining the difference between illegal and legal use, use ad bellum and use in bello. These are all still possible under translation. So it just requires us to be more creative international lawyers. And you can create new forums that develop these rules. So the group of governmental experts is an ad hoc UN forum that's now addressing issues of cyber war. So a lot of this is engaging new lawmaking fora. Now, your dean, Mike Sharp, has written about Grotian moments. He argued, for example, that when we had ad hoc tribunals and they were articulating the concept of joint criminal enterprise, that became customary law, even without decades of state practice. So we now have many, many more occasions where a consensus that a certain set of rules ought to govern a new situation can be treated as guiding practice going forward. And guess what? In this process, lawyers are the imaginative ones. This is a message I want to give to the students. Lawyers are creators. How many of you studied the Cuban Missile Crisis when you were undergrads? When they started that process, they find missiles in Cuba. What were the three options that were presented to them? Number one, do nothing. That's not good. Then you have missiles in Cuba pointing at Washington. Number two, ground invasion, months after the Bay of Pigs. That's not going to be so great. Number three, unilateral nuclear strike. Those three options are not great. What did they come up with instead? Quarantine. It looks like a blockade, but they called it something different. Approved by a regional group, the Organization of American States, combined with track 2 diplomacy to get the missiles out, the Jupiter missiles out of Turkey. And guess what? That solved the crisis. And you know what? Every single international law scholar who wrote about it for the next year called it illegal. And now it looks like lawyers creating a fourth option that created a better result. In that process, it is the lawyer who says, don't give me these three options and claim that they're the only ones when they're all bad. There's a fourth way to go. And if you look for that fourth way, that's consistent with the spirit of the laws. You know, when we were working on drones, there are some people who said, we think what we're doing is right, we just don't want to defend it. And then other people say, we can't talk about this, or we're going to have to release all the information. To which my view was, do you think what we're doing is legal? If so, we have a duty, we're the United States of America, to defend what is the line between lawful and unlawful targeting, and what's the line between lawful and unlawful detention. And people can disagree with us, but if they agree, we can eventually write it into treaties and statutes and other kinds of documents. So this is a challenge ahead, and lawyers are a critical part of this process. You're not just potted plants. You're not just scriveners. You're creative participants in a policy process in which the law doesn't answer all the questions on its face. You have to help interpret the law in light of modern understandings. And guess what? Originalism didn't work so great. Doesn't work so great for our constitutional law, and originalism doesn't work that great in this setting either. But following the spirit of the law is the object and purpose of the law is what international lawyers are trained to do.
All right. That's a great way to end. Thank you all for joining us today. The students should move rather quickly to your buses that are outside. The rest of you are free to come up and chat with Harold, who will stay for a few minutes. Okay.